Welcome to Hull on Estates, a series of podcasts for the Canadian legal community dealing with issues and insights surrounding estate planning in Canada. Hosted by the lawyers of Hull and Hull, the podcast will touch on some key considerations when planning estates and wills. Now, here are today's hosts.
Welcome to Hull on Estates. We're listening to episode number 686. I'm Jonathon Kappy.
And I'm Geoffrey Sculthorpe.
And today we are going to talk about the Absentee Act. How you doing, Geoffrey?
I'm doing well today. How are you?
I'm good. It got cold today. We had some warm weather, and now it's freezing cold, and yeah, I can live without it, to be fair.
I completely agree.
So we're going to talk about the Absentee Act today, and in particular, we're going to talk about the decision of Grover and Vaid, and a decision in which the court considered whether or not to declare someone an absentee. And some of the considerations that they took into account in reaching the conclusion that was ultimately reached. So, Geoffrey, why don't you start us off and tell us about what happened within this case?
For sure. Thank you. So this case concerned a woman who chose to return to India, her domicile of origin, and then chose to remain there. She could not be found afterwards. Ms. Vaid, the respondent, immigrated to Canada from India in 2013 and bought a house with her husband, Mr. Grover. The applicant in 2016. They took title as joint tenants. In 2017, the two returned to India, their native country, to visit relatives, and 2 days after their arrival, she decided not to return to Canada with Mr. Grover. He saw her last at the home of her parents in India. The parties were then divorced in 2019, and Mr. Grover remarried, and now has a young child. For years since then, Ms. Vaid failed or refused to answer Mr. Grover's many attempts to reach her to refinance the mortgage on the home they bought as joint tenants. The absence of the respondent's co-signature on real estate financing documents has caused the applicant untold misery, not to mention the economic strain on his new family. In 2023, Mr. Grover brought an application under the Absentees Act for a declaration that he was the sole owner of the house. So now I'm going to touch a little bit on the Absentees Act and its provisions. So in Ontario, the Absentees Act creates a legal mechanism for a person's affairs to be put under the management of a committee. So first, there is the due and satisfactory inquiry requirement. So the Act provides that the Superior Court of Justice may, by order, declare a person to be an absentee if it is shown that due and satisfactory inquiry has been made regarding their whereabouts. The court also has the power to direct such further inquiries to be made and proceedings to be taken as the court considers expedient before the order is made. It should be noted that a simple missing person report prepared by the police may be insufficient to justify a declaration under the Absentees Act. Applicants must be prepared to demonstrate they have conducted reasonable, independent inquiries into the missing person's whereabouts. An application under the Absentees Act can be made by any one or more of the missing person's next of kin, the missing person's married or common law spouse, a creditor, or any other person. And so now then we move on to the appointment of a committee. If the court is satisfied that there is sufficient evidence to declare the missing persons to be an absentee, Section 4 of the Act also empowers the court to appoint a committee for the custody, due care, and management of the absentee's property. A trust corporation may also be appointed as a committee with or without other persons. Where such a committee is appointed, Section 6 of the Act states that the powers and duties of the court and the committee are the same as the powers and duties of the court of the guardian of property under the Substitute Decisions Act, with necessary modifications.
So yeah, I think that that's a great sort of overview as to what the Absentee Act is intending to do. I think that when you think about the Absentee Act, you can't help but not think also of the Declaration of Death Act. But I mean, really the purpose of the Absentee Act is to deal with property belonging to people who can't be found, okay? And there's two different sort of scenarios that come up that the legislation has to deal with. People, for the most part, it's people who don't want to be found, okay? So the court was, I think, quite critical of her. I mean, she had this family, she owned this property in Ontario, she goes to India, she decides, I'm not coming back. Like, see you later. You can go back and enjoy your life. He tried to divorce her. He tried to serve her with divorce papers through the Indian consulate. It's unclear as to whether or not they found her or not, or whether just they made the efforts to find her. And she just didn't want to be found. All right. And so oftentimes when you see the court going through the legislation of the Absentee Act, the court is most concerned about protecting the interests of the absentee person. Okay? They don't want people to be dealing with the property of an absentee person willy-nilly, and it's treated much the same way as a guardianship. Okay. Interestingly enough, in this particular case, what the court does is it says that the courts have so far failed to come to grips with the true purpose of the absentee legislation. And he says that the true purpose of this absentee legislation is to protect the interests of those who are left behind. That this Absentee Act isn't intended to protect her rights. It's intended to protect his rights because he's here and he didn't walk away from his obligations to this property. He didn't walk away. And the judge says, listen, when you own property in Ontario, it comes with rights and it also comes with obligations. And you can't just walk away. And so what the judge is saying in this particular case is this legislation is actually designed to protect him. All right? You own property. You own this jointly. You walked away. You're not coming back. He's going to deal with this property. You left him holding the bag. So what are we going to do about it? And, for all the reasons, satisfying the legislation, dealing with the fact that, was she domiciled in India? Was she domiciled in Ontario? It's one of those things where, the day she leaves for India, she's domiciled in Ontario, but she made very clear 2 days into that trip, when she was in India, I'm not coming back. So did her domicile change as soon as she decides she's not going to come back? I think probably the answer is yes. She's now changed her domicile to India. She's staying in India. So the legislation deals with how do we deal with people who are domiciled in Ontario, and how do we deal with people who are domiciled not in Ontario. And in either case, the court says, so we are going to have her declared an absentee, and we are going to allow the now ex-husband to be the committee appointed who will manage her property as a guardian would. All right. And, the court recognizes ultimately this property is going to be sold at some point in time. And, because this person is not declared dead. They are still alive. It's just their property is being managed by somebody else. They are a fiduciary. They have to manage that property in the absentee's best interest. They have to account. All those things still apply. Interesting what will happen when this property is sold. All right. What probably should happen is that he's going to have to take half the property value, half the proceeds, and keep it for himself. He's going to have to take the other half and invest it for the benefit of this absentee person. But that's the court encourages him to get legal advice, and he probably should. So that's what the Absentee Act is about. Oftentimes when lawyers we're dealing with, is a person an absentee? Should we seek a declaration that they're an absentee, or should we seek a declaration that they're dead? Because that's the other option, depending on how long they've been missing, the circumstances under which they went missing. Certainly the courts are much more reluctant to make declarations of death. I mean, the consequences are much more severe, because when you're an absentee, the absentee person still owns their property. It's just being managed by somebody else. When a person is declared dead, well, their will is put into effect. Their property is given away. And if they ever show up, the statute has sections that deal with what happens if someone returns and all those kind of things. But it's a much more permanent and difficult situation to unwind if you have someone declared dead, or a court declares someone dead, and they eventually come back. So, but in terms of, the different types of tests, the absentee person is a person who, having the usual place of residence or domicile in Ontario, has disappeared, where their whereabouts is unknown, as to whom there is no knowledge whether he or she is alive or dead. So that's what you have to do to be an absentee. When we're talking about someone who we want to declare dead, the test is the individual has disappeared in circumstances of peril. So that is certainly one of the biggest tests that you have to overcome is did you disappear in circumstances of peril? The applicant has not heard of or from the individual since the disappearance. To the applicant's knowledge, after making reasonable inquiries, no other person has heard of or from the individual since the disappearance. The applicant has no reason to believe that the individual is alive, and there is sufficient evidence to find that the individual is dead. So, different test. Obviously, when we're talking about an absentee, the test is we don't know whether they are alive or dead. When you talk about trying to declare someone dead, it's we start talking about, well, is there evidence to believe that they're dead? Is there no reason to believe that they are still alive? And for obvious reasons. And so that's why you get into circumstances where you've got someone where, I think one of the case talks about it, where you find clothes at the side of the Niagara River and they're disappeared. Are they an absentee? Did they disappear in circumstances of peril? Well, you found the clothes. You found the canoe, but did anyone actually observe any circumstances of peril? It's not like they fell off a cruise ship into the ocean. That is a circumstance of peril. So interesting, obviously, when you're trying to decide whether or not you want to bring an application for a declaration that someone's an absentee or a declaration that they've died, there are different factors that you have to take into account. And sometimes you have someone declared an absentee and then you wait. And then later on, you seek the declaration that they're dead so that you could administer their assets. Because the Declaration of Death Act has a next section that says that not if they disappear in circumstances of peril, but if they're gone in a significantly long period of time. So that section says is that you can be declared dead if the individual has been absent for at least 7 years, the applicant has not heard of or from the individual during the 7-year period. To the applicant's knowledge, after making reasonable inquiries, no other person has heard of or from the individual during the 7-year period. The applicant has no reason to believe that the individual is alive, and there is sufficient evidence to find that the individual is dead. So again, it's waiting to see whether or not they come back. Now, the case that we're talking about is very different, okay? Because we know that this lady just doesn't want to be found. Maybe she gets hit by a bus and she dies, but generally speaking, she got to India, she decided she wanted to stay, and she just disappeared, and the court goes on about how easy it is to disappear in India. It's a free democratic country. People can do what they want. No one's being tracked. And if you don't want to be found, you're not going to be found. And so the court made the declaration that she was an absentee. So listen, I think that's all the time we have for today. We want to thank you for joining us. I'm Jonathon Kappy.
And I'm Geoffrey Sculthorpe.
Yeah, hope you have a great day.
Thank you. You too.
This has been Hull on Estates with the lawyers of Hull and Hull. The podcast you have been listening to has been provided as an information service. It is a summary of current legal issues in estates and estate planning. It is not legal advice, and you are reminded to always talk with a legal professional regarding your specific circumstances. To listen to other podcasts or to leave a question or comment, please visit our website at hullandhull.com. Our theme music is Upper Structure by DJ A Kid and is courtesy of the PodSafe Music Network.